We're here. We on the other side. Hey guys. Come on in. Hit the like button. Come on in. I love this song. It will never, ever get old to me. This is like my brand theme song. Like, can I get a like? Let's go. Hi, everybody. Welcome. We are going to continue the debauchery with the Young Thug trial. As you guys know, today has been a deadline for the filing, and I think I could still hear that music. Let me go ahead and hit pause. So, sorry, production and directing and all of that at the same damn time. I hope you guys are doing well. As you are filing in, I was just live with the lead attorney. We came over here to finish some of the documents that were filed today by all of the defense attorneys in the YSL case. Why is this important? Well, ladies and gentlemen, it's important for a few reasons. Number one, Judge Whittaker has to rule on all of these cases. And you guys know I'm a data nerd. So, of course, me and my team have been over here cooking up videos for you guys. We have one in production right now that is giving you a synopsis of everything that Judge Whittaker needs to look at on Monday. And the second thing that my team is working on right now, I polled a few of you guys earlier today on what you wanted to see. And a lot of you guys were like, can we see some best of Brian Steele moments? Those are coming too. So we are in the process of doing all of that. And throughout the day, we were working on those two productions. And then all of a sudden, the rain came from Twitter. And it was all of the PDFs from this case. All of the PDFs. And when I say that, me and Thugger Daily have a little, banter going on right now because I'm like, we need the PDFs. Lee likes the PDFs. Like, let's get those PDFs, right? But at the same time, they're all legal filings. And these guys are not just a number. They are actual people. And so 7 filings came in today. 2, I think, were for Young Thug, and the rest for the other defendants, and a few for the state. I've kind of suppressed my real opinion on it because, for those of y'all that don't know, I have a PR and a legal background of almost 15 years. And while I'm not actively practicing, I'm about to jump in and take the bar exam. That's why I'm up here in Boston and not in Fulton County right now, for good reason. They've taken a lot of my tax dollars. But the big thing with this is really understanding, number one, where your tax dollars go as citizens. I think that's why you guys like to watch us in an election year. But number 2, the big thing also was kind of looking at this from the hypocrisy. I don't want to go in because now I know these people are watching us on YouTube. I know for a fact, and shout out to my members. I posted it and I polled you guys earlier. I took the poll down because I didn't want to incriminate other people that could be involved. But I was just like, okay, it's super interesting to me that we are now starting to look at defense attorneys. And there are other cases on this channel that we've covered. And maybe that's why this thumbnail isn't trending right now, because we picked a specific person to be on it. And that's okay. But we did that on purpose. You bet your ass. That was on purpose, because you can't be in one place. And here's the thing, guys. I lived in Fulton County. I just moved up back here 3-4 weeks ago. So if I'm making $189,000 a year and my tax dollars are being funded into this case, oh yeah, we're going to talk about it. We're going to talk about it. We're going to talk about it. We want to talk about like women, like empowerment and doing their thing. And oh yeah, we gonna talk about that. We gonna talk about where my money went. That's why I'm super invested in this case. But at the same time, the people that are running the case are also saying, hey, y'all shouldn't be on YouTube talking about it. Defense attorneys, you shouldn't do that. Okay. What about the other leaders? And I'm not gonna go in. I used to advise a CEO for Capitol Hill and how he would respond to certain things. So I am going to be really honest here. I'm really disappointed. And whatever the hell media team is advising this team on how to move on this case, and to see that motion today, as I was collecting motions throughout the day, I was collecting them. Me and Lead were going live. You guys know, I pull these things. As I was pulling legal documents, I saw that one come in. I said, oh, y'all are funny. Oh, y'all are so funny. Let's see who we have in the building, and then we'll get started. I will continue to read the legal documents as unbiased as I can. It's going to be really hard. Having that PR background, guys, it's going to be very hard for me to do that, but I'm going to try my best. Shout out to D, who's in the building. He comes over from the other side and says, go AB7. He's like, let's go. Let's do this. And then shout out to Andrea Lowe, who has become a new member. Thank you, Andrea. And here's the thing. I poll you guys all the time. Whenever me and my production team, because it's not Team AB7, it's just not one person, like I have people. We get it done. It's a reason why this thumbnail was ready just in case. So I have the best team. I love them. I want to expand it. I want to continue expanding my team as I grow. I want them to grow with me. So I really run this channel like a corporation, and that will continue to happen. Anywho, let me come into the chat, see how y'all are doing, and then we will jump into the rest of these documents. Shout out to you, Pancake. Good to see you, Pancake. But who was first? Who was it? It was Jason. Jason was first. He says, tuning in. Good to see you. Linwood's like patiently waiting. Michelle's like, I'll be right back. Let me go get my popcorn. Everything I need. I'll be right back. Kat Knott Williams is in here. Huge sister to this channel. She is also a fellow creator that's been covering all of this. And I'm sure she has some thoughts on the motion that I'm going to talk to y'all about. Right? I wasn't on a comfort break. I think I was like 2-3 minutes late. I wasn't that late. But I'm here, and I can't wait. To get started. People are like, Fanny strikes. Okay, so science behind this. 7 motions today. And at least from the prosecution side, they come from Fani Willis's office, right? Did you guys know? Hold on, let's talk about this before we dive in. And again, you guys know me. I'm super organized. We will timestamp this up for everybody that is watching on replay. Do you guys know that Steve Sadow was one of the defense attorneys on this case? And do you know that Steve Sadow was representing Sergio Kitchens, who was Gunna? The rapper Gunna. And y'all heard Young Thug's kids calling Gunna a snitch. I saw that. Y'all been like, please respond to it. So all of that is happening. Steve Sadow is also representing President Trump in this Fulton County thing with Fani Willis. And then we found out that, like you have 2 parties, President Trump, Fani Willis. But she hits President Trump with the RICO charges too. And I know, we don't want to go into politics over here. We're not going to do that tonight. But the point is that both of these cases, both the YSL trial and also the Trump trial, in Fulton County are both RICO cases. They both have multiple defendants. The defendants in the Trump trial, there's like 7, 8 of them. I'm not quoting the right amount. Y'all gonna be in the comments like, you didn't have the amounts right. Okay, fine, whatever. It went up on appeal. It's frozen until after the election, and Steve Sadow has been the #1 defense attorney for President Trump. And I like to call him Boots because he wears these like really expensive, high quality cowboy boots to court. And you guys know, like sometimes Lee and I would watch these proceedings, and sometimes we'll look around in the courtroom and just see what's going on. Like you guys called one dude nose. He was always up in his nose. And you know, like when Boots would talk, he had very compelling arguments. But he also, I would like notice his shoes. I'm like, look at them boots. Those some pretty serious boots. They are. So Boots would show up and he would either ask some really compelling questions. I also think that Ashley Merchant was great in those hearings, and that was back in the spring. And guys, we're in the summer. We're almost in late summer. And that case is still progressing. But what I noticed today, because me and editor #2 are working on, we were working on, I asked you guys what y'all wanted to see. We're working on the best of Brian Steele. And I was pulling some like savage moments from Brian Steele. Y'all gonna love it. And like in one of the like court proceedings, I saw Steve in there. I was like, yeah. I was like, is that Boots? I was looking at the screen as if I was watching it with you guys. I said, is Boots involved in this trial too? And then that's when I saw that he was Gunna's lawyer. Why you think Gunna's still doing performances out right now? These guys really, in Georgia's small. Me being a northerner and living out there for a little bit, I saw just how small Georgia is. Atlanta, even smaller. Buckhead, even smaller than that. I saw just how small it is. So when it comes to you being a person that has money, being the elite of the elite, you're going to know where you need to go to get a good lawyer. The fact that Gunna had the same attorney that President Trump has right now, there are times I'll be on with Lead and I'll just be sitting there because there's stuff I want to say and I'll just be sitting here like, but when we're on my side, we can talk about it. Over there, I can't see it. But over here, I can. Over here, I put in really, really deep research to the point, guys. And I had a discussion. Let me see if I can bring it up. I had a discussion with a founder of a company like 2 days ago because I was looking at Judge Whittaker's like stats. That's really important to me. You guys have been itching for that. So before I show you these motions, that's also another thing that I want to start with. Let's go into Judge Whittaker's background. Let's go into her ruling stats. That was supposed to be for tomorrow's video, but we'll do it for right now. Let's get to know this woman and see how she's going to rule, because I'm going to show you a shit ton of motions right now. But really, the thing that matters is how she's going to rule on those motions. Is she going to be favorable to those motions? Is she going to deny those motions? Just because a lot of motions start raining from the sky, does that mean that those motions are going to be granted? No, it doesn't. It doesn't mean that at all. Okay, I think I have it on my desktop here. This is the thing. So like, if y'all notice, if you just came from the last stream and like Lead was like, are you going to do this on your side? I was like, I would have loved more time, but yes, we'll make it happen. We will make it happen. Give me 1 second, guys. I think I need to like open it first and make it a Chrome tab. I need a producer. Do any of you guys want to like volunteer to be my producer? That would be fantastic. Okay, here we go. I think I have it. Let's start with diving in to Judge Whittaker. So we're going to go here. Judge Whittaker works in Fulton County. You can look this up yourself, it's fultoncounty.org, and you can look this up, right? You can look at the judge section and you can see that Judge Glanville is presiding. He is the chief judge out of all of these judges. We see some familiar names. We see Judge Krause on here. We see Judge Whittaker down bottom over here. And we're also going to be seeing Judge McAfee. That's where we see from the Fani Willis, sorry, I'm trying to get that right. And we also see Shakara Ingram as well, who, between her and Krause, from Judge Glanville, this went to Judge Ingram. And then it went from Glanville to Krause, then Ingram. And then after Ingram, it got transferred to Whittaker. So you see just in this very small group of judges that it has been bounced off of about 4 people. So, my team is working on a full-blown video for you guys on this right now, so I'm not going to spoil it too much. But if you are interested in learning more about Judge Whittaker, her information is here. But what I want to do is I really want to get into stats because I'm a nerd. I like data, and data tells us a lot about people. So let's see. I think I need to minimize this a little bit. Struggle streaming. Can I get a like for it? Okay. Share screen. Window. Here we go. Boom. All right. This is Judge Whittaker's information on how she rules. And in particular, I want to show you guys this screen right here. This shows shows us her motion grant rates. It also shows that her grant rate for motions in general is almost 5% lower than the average county grant rate of 54%. So she's at about 52%. So she's in the middle. And if you look at where my mouse is on the screen, she's literally, like, I'm not even kidding, in the middle for how she grants motions. Before I get into this pile of motions, I really do think that data like this is important to look at so you get some background on the judge that we are talking about. And we have an understanding on if she's going to grant some of these motions. Like I said, 7 of them came in today. 7 of them are what I'm going to show you, but it doesn't mean that all 7 of them are going to be granted favorably, or, in all honesty, if they're going to be granted on the unfavorable side. But you need to know this because it really all depends on how she grants motions in general. Now, this is data. Does it mean that she's going to adhere to this? No. This data tells us about her habits. Habits are really important when it comes to human behavior, and judges are humans, right? So her rate is 52%. In the middle, it shows you like how she stacks up against other judges in the same county. And down here, this purple section is where she stacks up against other judges in the state. So being down here in the 52 percentile, that's actually pretty good. It's actually pretty good because on the super right-hand side of it, you see that some of these judges are at the 60 percentile. So it's really only 8% of a difference that we're going to see. I want to take you guys here because there's 2 things that I want to show you. That was her motion in general, her motion grant rate in general. Let's look at grant rates for summary judgment. Why do we want to talk about summary judgment? And this is when I get really geeky with law stuff. Summary judgment, a motion for summary judgment is if, hey, I'm a defendant and I'm looking at the state, they're bringing everything, and I'm saying, hey, judge, there's no issue of material fact that should continue on to trial. There's a reason why the judge switches out here. You get a ton of motions because you have a new judge. Now, are some of these motions for summary judgment? No, but I want you guys to see what her motion rulings are like in general. Summary judgments are interesting. We're going to explain that more in the video that will probably drop for you guys in the morning. But let's check this out. Look at this. And let me come over here and make myself small. So, motion grant breaks for summary judgment. We see on the green levels. On the left, you see where Judge Whittaker stacks up. In the middle, you see where Fulton County stacks up. And on the right, you see where the state of Georgia stacks up. Now, Whittaker herself, she's 3% higher than the county's average rate. So this actually might be really good for Teen Thug or any of the other defendants on this case, because she seems to be a little bit more in the middle than other people. I mean, it's still around 40%. Overall, it's still around 40%. So that tells me this county and state may lean more towards the prosecution. In general, Whittaker is a little bit higher than the county's average. She's still at 44% though. And you can see that red part in the middle for her section on the left-hand side, it says denied. So pay attention to that. In the middle, we see Fulton County. Fulton County tends, when it comes to motions for summary judgment, and guys, these are typically entered at the beginning of cases. I just wanted you to see that because technically she's getting this case for the first time and everybody's clobbering her with motions right now. How effective are these motions going to be? They are all of these attorneys, prosecution and defense, have done a pretty good job at explaining what was going on within the motions, right? They do really well at arguing. I do like to see live footage, like you guys, you know what I'm talking about. Like, we like to see people in action versus like paper. You know what I mean? But like, these are things that matter in the court of public opinion too. So many of you guys were like, hey, AV, that thing you did where you showed us data on these judges. Because I did this for not just Whittaker, I did it for the previous judge. And then like I canceled the subscription because I was just like, why am I, paying all this for a report every single time if I just need it on one judge? And like the CEO and then CMO, which you need to call me, was just like, oh yeah, we need to have a call to discuss your needs. And I was just like, well, honestly, guys, I didn't want to show this data tonight because they need to call me. But it's okay. It's okay. All right. Business is business, but we're going to focus on this. But look at this. So this is kind of showing you an example of her ruling rates. She does land in the 50s. And with motions for summary judgment, what is concerning is she lands in the 40s with these. Okay. That's just on its face, right? Now let's go down. What I will say is a positive is this. When the motion is filed by the defendant, she seems to side with them more than Fulton County and the state of Georgia. So that's actually really good. That shows that she can take herself out of it. She'll look at what the defendant and what the defendant's team is putting forward. She'll read the case law and she'll rule a little bit higher in the favor of defendants. Okay, so this is a really good thing. Look at that blue line on the right hand side. It's blowing past Fulton County's average, and it's blowing past the state of Georgia's average. This is really good. This is really good. So I do think, and based off of how she set those ground rules last week, I think this is going to be a good change for everybody involved in the state. The defense attorneys, the prosecution. She has a history in the prosecution's office. Hopefully that's not going to be a bad thing. I think it's going to be a good thing because based on her stats, it looks like she is going to be relatively impartial. Right? So that's good. Again, when I think about putting together videos for y'all, I really start to look at pieces like this and we want to stitch it together in the right way where the story makes sense instead of just like a bunch of little Woody videos. Like, no, we want to make sure like y'all are walking away with something from this. That's at least what me and my team do over here. Popping into a few supers, and we're going to look at all the filings from today. I'm going to do it fast. It's late for y'all. Like me on the East Coast, you California people, you're chilling. And everyone else in the world, it's like tomorrow. So we're going to do this super, super quickly. I think I caught D, but shout out to Captain Jones. Captain, I haven't seen you in so long. Captain Jones drops me $20. Thank you so much, Captain Jones, and says, thank you for the summary. Great job. I'm glad you like it. And again, like it usually like I take more time to piece together how these videos are going to go because I really want y'all to learn something. But your girl also can't be on live stream all day. Me and Lee, we've been doing the damn thing. We've been on the streams for hours, past few days, But, when we are not streaming, like this is full-blown production. Like I want y'all to know that. Any single person that donates anything to me or my channel, like this is what you're investing in. And I will absolutely perform for my shareholders. Let's just say that. Thank you so much, Captain Jones. Good to see you. Look at this. We have a stream sponsor already. T-Brick, $100 says, keep up the good work. T-Brick, thank you. First off, super generous. And T-Brick, I think you're a newer name in my community. I try to do my best to remember things about you guys as I learn about you. So T-Brick, thank you. And you're the stream sponsor today. Like you're sponsoring this stream and you're going to give me the energy that I need to go in and read all 7 of these documents fast. I'm going to make them snappy, guys. We're going to get them quick. Like, you're not going to be here for 2 hours. Like, no, we're going to get through these fast. So T-Brick, thank you. And if you guys can do me a huge favor and type T-Brick in the chat, that would be fantastic. He is your stream sponsor. And I always say, like Lead says too, I learned from him. So you guys are like, sometimes you have too many similarities. Like you have his laugh sound. But I experimented with a few. You love this, T-Brick. I experimented with Kill Bill because that's like my favorite movie ever. I experimented with this stream sponsor sound that was like totally Kill Bill. Look. This is just for you, T-Brick. But like people thought that was like annoying and corny. So like, anyway, if y'all could type in T-Brick in the chat, that would be fantastic. He is your stream sponsor. I promise, guys, I'll get this right at some point. We got to make it me, but we'll do that. And I like data and asking y'all for information. So you help me with that. Okay, perfect. T-Brick is our stream sponsor. Thank you guys so much for shouting him out. I love to see it. I love to see all of the All of the love over here. Y'all are like AV for president. What is going on? AV for president. I love it. I love it. Valhalla's in here too, breaking it all the way down. Let's go. Let's go. All right. Without further delay, when we have people like T Brick sponsoring streams, I'm not going to wait. I'm going to pull up every filing. The ones that Lead and I went through, I will skim through. Okay. Just to give you a recap, 2 minutes, maybe less than 1 minute. Let's do this. So we're going to share screen. I'm going to start with this one. I had some opinions on this one. Here it is. So this is the state's filing from the day. Oh, y'all didn't see this one. State of Georgia, and it's their motion to exclude victim character evidence. Who are they talking about here? Well, they're talking about little Woody here. The state believes that the defendants in the above styled case may attempt to improperly place the character of the deceased victim, Donovan Thomas. Oh, ladies and gentlemen, let me take that back. They're not talking about little Woody in this document. They're talking about witness information that they have about Nut. Nut, the gentleman that passed away, the murder that is at the core of this entire RICO trial. They're talking about Nut here. So I thought that they were going to try to preserve little Woody's testimony because we know they need it. But at the same time, now we have to see, what are they about to say about Nuts? And Judge Whittaker has to rule on this motion on Monday. Let's go in. Let's go in. What do they want here? So they say, the state believes that the case may attempt to improperly place the character of the deceased victim, Nut, in the issue at the trial of the case. For the reasons stated below, the state moves this court to prohibit any attempt by defendants to elicit and introduce any improper character evidence as prohibited by OCGA. These are the statutes that they're citing. All right, let's see what they say. Defendants Kendrick and Stillwell are charged in count 2 with the January 10th murder of Donovan Thomas, aka Nut, for overt acts in their giant RICO conspiracy 16 through 20. Count 1, conspiracy to violate the RICO Act, also pertains to the murder of Donovan Thomas. The defendants have pled not guilty to both count 1 and count 2 and have never raised or asserted any claim of self-defense. Here's their argument. Georgia evidentiary statutes, I'm going to skip those 2 sections, govern admissibility of a victim's character. These statutes generally limit evidence of a victim's character to reputation or opinion and not specific bad acts. Y'all, do you know why they're saying this? Wasn't Nut in the streets too? Weren't these nuts in the street? Nut was in the street too. So if your murder victim was in the streets as well, I mean, you have to cover up what he did. That's what. That's what this document is. The state is putting forward that they don't want any bad character evidence coming up against Nut in this case. I mean, here's the thing though. Can you cover Nut's wrongdoing when Nut is not there to defend himself? Can you do it? Can you? So if someone were to want to cross-examine Nut's gone. Nut's not here. Let's continue before I make probably some bad statements. Let's just keep going. OCGA section 24.4.404A provides an impertinent part as follows. Evidence of a person's character or trait of a trait of a person's character shall not be admissible for evidence for the purpose of proving action in conformity therewith a particular occasion. There are 3 enumerated exceptions. 1 is if the pertinent trait of the character offered by a party to rebut the same. 2, the evidence of the victim's character trait for peacefulness to rebut the evidence that the victim was the initial aggressor. And 3, if the evidence of the character witness, it looks like I have a footnote there, where evidence of a character or trait of a person is admissible, proof shall be made by testimony as reputation or by testimony in the form of an opinion. This is what I was saying, guys. It's like Nut is not here to give us one, right? Because no one can rebut the same of the exceptions. Those are the 3 exceptions. 2, Nut is not here. So we cannot look at his character traits for peacefulness and rebut that evidence. And 3, Nut is not here. So how are we going to have actual evidence of the character witness? Now, what needs to be done, and they say this here, is we need testimony as to reputation or like from other people or by testimony in the form of an opinion by other people. So you need the person themselves or you need another opinion. Generally, here it is. A murder victim's character is irrelevant and inadmissible. A victim's character may only be admitted if there exists some factual nexus to the conclusion for what it's being offered. It is impermissible to establish such a nexus through sheer speculation. Even if cases where an accused is arguing self-defense, the accused may only seek to introduce evidence of the victim's violent character through the admission of reputation and opinion testimony. B, the character of Donovan Thomas, aka Nut, is irrelevant and inadmissible in this trial because there exists no factual nexus for the introducing any evidence pertaining to his character. Furthermore, any evidence of the victim's violent character is unequivocally and irrelevant because no defendant has claimed self-defense. Oh, and going back to that law that I showed you guys. Finally, even if the court were to find a relevant purpose for victim character evidence, it can only permit admission through reputation and opinion testimony, not specific acts. I'll go into that in a second. Conclusion, the state requests this court prohibit defense from intentionally or inadvertently eliciting improper character evidence. So the state is like, y'all can't talk about Nut. You could talk about him. But, you know, when it comes to character evidence, and I wish I had my books, and sorry, guys, the studio's under construction right now. It should be done in a week. I'll be back to the law books, all of that fancy stuff. Character evidence falls under the federal rules of evidence. And I see the book in my mind right now. I want to show it to you. I want to break it out and show you what the rule means. But character evidence is really discussing a defendant's character, their habits. What do they do? What do they do every day? You, as a defendant, if you have a tendency to rob a store, you rob that store. How do you do it? What do people around you know about your character? Do you have a tendency to do specific things? Nut, in this case, is not here. because he's one of their murder victims. The state needs to prove that all of these 6 defendants conspired under RICO to kill Nutt. But if Nutt is not here to defend himself, what the state is attempting to do is they don't want character evidence that has to do with Nutt, his history, and all of those things to come up. If you have a murder victim that was also, I don't know, I'm saying it, convicted felon, maybe he has a criminal history, whatever the case may be. I don't know much about Nutt's history, so I don't want to misspeak here, but I'm giving you an example. They don't want Nutt's character and history to come up. 1, because he can't defend himself, and number 2, he's a murder victim. But, you know, like, if you had a murder victim that was alive, I mean, you really couldn't do this regardless. So anyway, that was the court's filing today. New judge, everybody's putting it all on the table. That is one of the first filings from the state. They don't want anybody on the defense team to bring up Nutt's history or his character evidence. Let's go to the other document from the state. This one is the one that got me hot. It is. I am a huge advocate for free speech. It means a lot to me, and it should mean a lot to you guys. But let's come to this one. Okay, I'm going to skim through it because I did go through this with lead. So we are going to quickly skim through it. But basically, the state did not want defense attorneys in this case. Any of the 6 defense attorneys, Steele, they didn't want Weinstein, they didn't want Shard, they did not want Harvey, they did not want Angela. And you know, at this point, I'm so sorry that I'm forgetting the 5th and 6th, you know, defendant attorneys' names off the top of my head. They don't want any of these attorneys talking to people. But what really, I'm going to say, because we're on my channel, what really pissed me off was 2 things. 1, I have a PR background. I did this for a CEO for one of the nations, the US. Top 4 banks. I've been doing this for 15 years. So when I saw like attacks at the press or defense attorneys not being able to speak to the press, because that's essentially what this motion does. This one was the one that, I'm not going to lie to you guys, it infuriated me when I saw it. Exhibit A, which is like what I have on screen. I'm not going to read it. Exhibit A is Brian's, and like for those who don't know what AP is, the Associated Press is typically an outlet where you can produce one media statement, and this media statement would be trickle out into the masses. It would just float all around, and it would go to the other media companies, and those other media companies would quote the AP. They would say, according to the AP, when they say AP, they mean Associated Press. That means it's the one place where someone has given a statement. I was like, is this an Exhibit A? An AP statement? Brian didn't even do anything here. Like, he didn't. Look at this. Look at this. I know I'm not crazy. It says, please find Brian Steele's statement regarding the recusal order. And all Brian was talking about here was like Judge Glanville being recused from the case. Jeffrey Williams is innocent of all the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he could receive constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered recusing and disqualifying Judge Glanville from presiding over Mr. Williams' case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. Where's the problem? You know what the problem is? This is getting deep. I'm telling you guys, I sat here this morning with editor number 2, and we were looking up Brian Steele's savage moments. I didn't even realize how many fights he got into with DA Love, how many fights he got into with Judge Glanville. This shit is personal. I'll say it. Why is this exhibit in here? They got a favorable thing for their client, and they're putting it out to the AP. I'm telling you, there's a line in here. Let's go back in. There's a line in here where I know the DA's office didn't like it. And I think it was the prosecutors have run afoul and their duties under the law. I don't know if it was that, but if you look at these lines of exhibits, and I wish, sometimes guys, like when I'm on lead side, I can't talk like that. Like, I do, but at the same time, I want to go in, but I can't really go in like this. Like, it's my platform over here. They might try to demonetize me next. Who knows? I don't care. But this is serious. He gave this statement to all news outlets. What the hell is wrong with this? Let's do. Where's the problem? Why is this in Exhibit A? Why? Tell me where the problem is. I don't see it. My client's innocent. He's trying to clear his name and get a speedy trial. One where he can get constitutional guarantees and a fair trial with an impartial judge. Here's where it is. Ethical prosecutors following the law. They got hurt over that. Sadly, Judge Glanville and the prosecutors have run afoul. Brian came at their neck, but it's still professional. Mr. Williams is grateful that the reviewing court, the new judge, we're moving on. That sentence right there is the new judge moving on, agreed with him and entered an order recusing the last judge. That's okay. We look forward to the new judge who will fairly and faithfully follow the law. Why is this the first thing that the state has put in their exhibit list? Yes, D is out. I mean, I read this early and I was like, are you kidding me? Mimi, girl. Okay, let me keep going because that's not the only exhibit in this one. This is their document actually made me really upset as a communications professional. And I say that being that I really thought it was unfair. I really did. That was Exhibit 8, this tiny paragraph that Brian Steele put out to everybody. They're like, oh yeah, this is what he's doing to get at everybody. Second thing, Lead and I showed this. They're now targeting YouTubers. I think this is Megan Kunif's channel. So if they watching Megan, you think they're not? You think they're not watching this? They're watching this. The First Amendment will always preside over here. Whether you agree with one side, whether you agree with the other. And a lot of times, I actually do call it fair. But now we're looking at YouTubers. Oh yeah, let's go back in. So I'm not going to click on it, but they had full timestamps. This is Keith Adams. So they're trying to say Thug's team, Exhibit A and Exhibit B, you're talking too much to the media. First one, I think, is standard. You're going to put media statements out. I really don't see an issue with Brian Steele's thing. I really think that they got butthurt over that. Keith Adams, yes, when Lead and I looked at it earlier, he did mention a few things regarding the case. Maybe he shouldn't have done that, right? But look, they got so intricate as to timestamps. And some of these timestamps, guys, look. Seconds. 7 seconds. Another 7 seconds. Where is free speech anymore? 7 seconds. I'm going to keep going. Let's go to Exhibit C. What's here? Oh, it's another Associated Press thing. And they reached out to Glanville and to a lawyer on Young Thug seeking comment for Monday's ruling. A spokesperson for Willis's office declined to comment. I can understand why they did that. But Doug Weinstein, a brother to this channel, he made a comment. It is one sentence. It says, while I respect Chief Judge Glanville and his service to this community and the country, it starts with positivity. He simply became biased over the course of his case. He added to the second part of that sentence, before an unbiased judge, but said only just outcome at this point, a mistrial and bond for Kendrick, who has been jailed for 2 years. This is why it saddens me. Because when Doug was over here, I actually wanted to let you guys learn more about Diamante Kendrick. I wanted these attorneys to be able to speak more about their clients because there's so much that we all see on TV. And if you are charged with an interview that is not something where they can comment on the case, and as a legal scholar and a communications person, I know that. So, I'm like, hey, here are these questions beforehand that I know are clear in a green space that I can ask you. Because I understand that there's an active trial happening right now. Right? Y'all know some channels were started recently and are gone now. And I do think, just my suspicion, that some of this is connected to that. So in a way, no shade to the prosecution's office. It's a big case. But here's the thing. If this was a concern, why wasn't it brought up at the beginning? It wasn't. Let me not say it wasn't, because it could have been. But I do think that it should have been more of a concern at the beginning. Young Thug is a celebrity. I mean, granted, you want to call him King Slime, all of that, like, the wolf, all of that. You really need to focus on this a little bit more closely. And shout out to Kat and Hot Williams. I see her cutting up in the chat. I haven't been able to look at it, Kat, but I see Kat cutting up in the chat because she's a creator too. I mean, these are things that should have been baked out at the beginning. And now that there's a new judge, like, I almost feel bad for Judge Whittaker because now everybody's throwing spaghetti at the wall. Like, it's like if you had a Nerf gun with spaghetti in the joint and you just load it and you're like, everybody's getting lit up. All of them. So now we're coming at Doug. And Doug was over here. That's Exhibit C. Let's keep going to Exhibit D. This next one, same thing, Megan Kunev. And again, she's an actual freaking journalist. Sorry to call her that, but she's an actual legal journalist. She does this for a living. She has done it for a long time. The fact that a YouTuber is on Exhibit D. So, like, this is how I wanted to go off on lead side earlier. I'm like, okay. Exhibit D from the state is from a YouTuber. Let's keep going. I know they're watching. Let's go. Let's go. Let's go to Exhibit E. Same thing. Megan interviews Max Shard. Guys, another defense attorney from the case. That's the exhibit in this affidavit. Are you kidding me? Or in this motion, whatever. We want defense attorneys to never speak about this trial at all while it's ongoing. Okay, yeah. Timestamps and all of it. Oh, you want me to look? Times, all of it. Timestamps, all of it. They put that in this legal document. On Megan's channel. Leave Megan alone. You keep going. Exhibit F. Guess what? Another YouTube channel. Look at this. This time they got many timestamps. 1, 2, 3, 4. 4 timestamps. Coming at Doug because he's talking about the case. Then they served it. Let's go to the top. Let's see what the state has to say. But like this is an attack on free speech. And, you know, I've not had an opportunity to have Woody on this channel. But your star witnesses all over the goddamn internet and ain't nobody. Where's that motion? Huh? Where is it? I'm looking for, did y'all see, where's that motion at? Have y'all seen that? Where? We're coming. Let's keep going. I'm just going to leave it there. This is the only one that really pissed me off, guys. Like, I'm not even kidding. Just as a communications professional that has worked for a Fortune 500 company, I thought that this was very, not poorly written, but I do feel like it was unfair. I understand the intention behind it, but I do think that this is really unfair because whenever you have an argument, you need to look at yourself before you come at the other side, and you need to strategically think about that because it really is a page and a half. That's it right here. Look, page 1, page 2. It's a page and a half. And all it's saying is, hey, state of Georgia, coming to you, new judge, to instruct the defense to refrain from making any further extrajudicial statements about this case moving forward. You could hear it in Adrian's voice. Rule 3.6 prohibits lawyers from participating in litigation from making extrajudicial statements to a reasonable person that a reasonable person would believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it would have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. A relevant factor in determining the prejudice is in the nature of the proceeding involved, with criminal jury trials being the most sensitive to extrajudicial speech. All of this right here, you see this big blue part? It's all in quotes, and it's all case law. So they start with, hey, stop them from doing this. Here's the case law. Now I'm telling on them. I'm saying that defense counsel have made numerous statements explicitly by this case while a jury is sworn and seated in the state's case in chief. This is where I lost it. I said, you're really gonna sit here and look at these 6 criminal defense attorneys? Brian don't do interviews. He put out an AP statement. But let's look at this, guys. Look at the sentence. The statements about this case while a jury is sworn and seated in the state's case in chief. Whose case in chief? Not the defendant's side when they're up. It's when the state is up. So we are saying that when y'all are up delivering your case, all your evidence that are supposed to convict all 6 of these men of RICO charges. Fine, prove it to us. But are we seriously not going to talk about your star witness running around the internet getting millions of views? I can't talk about it anymore because I'm going to get hot again. Let's move on to the next document, but we're going to take a super chat break because defense attorneys, and some of them did talk about it, yes. 6 defense attorneys that are attorneys are going to be careful versus your witness. And again, no shade to Woody. Woody doing his thing. Woody, get this money, Woody. But like, you need to focus on that. Shout out to Drew Beats, who says, was watching you in lead on replay and just saw you live. Glad you guys are back. Me too. It's been a few days since we have been back on the platform, but again, we were going back and forth on this earlier. I was like, oh my God. I read that one and I was like, I can't. I really can't. So thank you, Drew. Appreciate you. And I hope all is well in Vegas and it's not too hot there today. Hope it's not too hot there today. Shout out to King Jiggy with the $20 who says you're great. Thank you so much. Sometimes I get into my Boston form and that's like when I would be your number one attorney. Like they don't like it. Like I can turn it on and off, but when I go in, listen, I'll go in, King Jiggy. Like I'll jig for you, Jiggy. Like I'll go in. I feel like Brian sometimes with going in for my clients. Like that is what would happen. But again, when you have arguments, and when people start to deconstruct them, this is where you could start. Imagine if you were a lawyer, dear viewer, and you received that document and you saw and you were like, oh my God, how dare you, right? And you needed to start to deconstruct it. You would have to look at that. Okay, let's look at both sides of the coin. A coin has 2 sides. It has the heads and the tails. Well, okay, if we're going to apply that law, it should apply on both sides. And where it doesn't apply, then we need to go from there. I do think that sometimes this case can be, and I'll give the prosecution this because they're likely watching, their investigators, whoever. Hi, good to see you. If the prosecution is watching, I do think that their disadvantage is that there are significantly much more defendants for counsel than there are of prosecutors in this case. That sucks. It does. It's terrible. And that makes this incredibly hard. But if you guys have noticed a common theme over the past few weeks, it's like we're seeing, defense counsel, there's 6 of them. You're seeing defense counsel file documents and they're lengthy, they're long. Prosecution side is 1 or 2 pages. Now I'm starting to understand why, because they have to respond to all of this at the same time, and then the judge has to rule to it. The judge has to collect this big collection, this bucket, hey, we have 7 documents to rule on today. Prosecution, what responses do you have to this one? Or to this one, or to this one. So I want to be fair and at least say that. I will say that. To have the judge stop it all, a little crazy. It's a little crazy. Shout out to Jess Morandi. Looks like you're you're an Aussie. You're coming from Australia. It says, hey, AV, many thanks from Australia. Hi. What time is it there? Are you just waking up? Let me know what time it is over there, Jess. I would love to know. Thank you so much. I really appreciate you. Shout out to Trainwreck Entertainment with the $50. Thank you, Trainwreck. Says just because. I appreciate you. If any of the mods are hanging out, Trainwreck Entertainment, if you guys are interested in legal commentary and legal proceedings, I know that they cover a lot of localized cases over there. So please check out their channel. They do great work. Thank you so much, Trainwreck Entertainment. Really appreciate that. Generous super chat. Appreciate you guys. King Jiggy's back with another 20. Says for your time. Thank you so much. Appreciate you, King Jiggy. And then we are back again with Trainwreck with the 50. And the curly hair is beautiful. As KS would say, natural is the best. It is. It is. I'm happy that I went down this route. All right, y'all. Let's go back to this document that did not make me happy. We're just going to finish it and we'll go on to the next one. Anywho, so they basically say that Young Thug's lawyers, Brian Steele and Keith Adams, defendant Kendrick's counsel, Doug Weinstein, defendant Stillwell's counsel, Max Shard, have all made extrajudicial statements to the media discussing the case in violation of Rule 3.6. The statements have included, among other things, interviews and statements to the Associated Press. 4 of those interviews have been 25. This is irrelevant. This is not relevant. She's saying that there is a violation of Rule 3.6. Okay, tell me how the rule is violated. If I'm a judge, I want to see that. She's saying that the statements included interviews and statements to the AP. Okay, you're still not telling me how they violated it. Next sentence. 4 of those interviews have been 25 minutes, 33 minutes, 43 minutes, and 107 minutes in length. Okay, great. Land the plane. The statements, among other things, the attorney, I think they should have said include, among other things, the attorney's views and opinions about the case itself. Okay, so this is the big part that they're complaining about. They shouldn't be talking about the case itself. They shouldn't be talking about opposing counsel. And they shouldn't talk about the now former judge. They don't want us to talk about Glanville. They don't want us to talk about the jury. They don't want us to talk about the outcome. They don't want us to talk about the guilt or innocence of specific defendants. The statute says the court has the power to control the furtherance of justice and the conduct of its officers. So she's basically saying, here's the problem we have with this. Judge, you have the authority to rule on this. You need to let us know. So we are asking you as a state to instruct the defense team from refraining to make any statements about this case moving forward. Adrian Love, right? Interesting. No, I mean, we're going to keep going. We're going to keep going. Let's go to the next document. Okay, this one I read with lead, guys. Let's go in. This is King Slime, Jeffrey Williams, Young Thug, asking for bond. So this was a little bit new for us, but he was asking for bond. What does that mean? That means he's asking for bail or some sort of accommodations to be made so he can get out. So this is why I keep saying that Judge Whittaker is getting hammered with all of these motions all at once. Like, you see how we're shifting topics? So we go from the media thing. The prosecution team does not want media. She doesn't specifically want us to be talking about it on YouTube. We don't do it anyway. But now Young Thug is looking at getting some time out of jail. And Lead and I went through this, so I'm not going to go through it too much. Brian Steele tends to use a ton of case law, and he's just kind of. I'll bring you guys to this section right here where he talks about the state has to prove that he does not pose a significant, or he needs to prove he doesn't pose a significant risk to flee the jurisdiction, so that he's not going to leave Atlanta while the court action is happening, that he's not a threat or danger to the community, right? He's not at risk to commit a felony while on bond, and he's not a risk to intimidate a witness or obstruct the administration of justice. Now, what Brian does very well, you see how I show you guys these 4 sections when they argue? What Brian does very well is he'll take each one of those sections and he'll start giving you reasoning and rationale behind what their argument is. So the first one, he's not a flight risk. So Brian goes into at least 3 paragraphs and talks to you about that. He's not going to be a flight risk because he's one of 11 children. He's a father of 6 children. They're all under the age of 16. All of those kids live in Atlanta, so he's not going anywhere. Although he is a rapper, he has enough money and works really hard at all this where he can do it at home and includes clothing lines, modeling, the owner of a successful record label. This is all work that he can do from home, and he has a strong history of lawful employment. So as you can see, Brian Steele's going in on that. Second argument, he says, Young Thug is not a threat to the community or any person or property in the community. He's going to give you a full argument on that. Me and Lead read through that, so we're not going to go in. He also says Young Thug is not a risk to commit a felony while out on bond. Okay, so they're talking about a search warrant, some of the indictments that happened, all of those things. And then 4th, he's not a significant risk to intimidate witnesses and things of the like. What's really important about this, and I can't find it here, but I think it's closer to the end. Brian Steele basically says to the judge, hey, we have an opportunity to get out on bond, and I'm going to renew this. Judge Glanville denied it 3 times, thrice. Now I'm going to put it in front of you. I'm putting it in front of you for fresh eyes, but listen, we will pay for everything. Young Thug has the means to pay for everything. If you want him to stay in the house, he'll stay in the house with an ankle monitor. If you don't want him to go anywhere, he won't. If you don't want him to intimidate witnesses, blah, 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 we won't. Even to the point where he has so much money, he can hire some of the people that work for the Fulton County, law enforcement area to preside over his home, so you guys know he is not going to go anywhere. They've already secured. They found a bond company. So let's see if this judge is going to secure a bond. Let me know in the chat, guys. If you think that Young Thug might get out on bond, do you think Whittaker will grant it? Given given the data I've showed you, put a 1 in the chat. If you think he's not going to come out and she's going to deny it, put a 2 in the chat. I'm very curious to see what you guys think. Some of y'all say yes. Y'all not forget the 1s and the 2s, AV. No, yes. Look at this. Look at this. D says 1. I see a mixed bag. I see some 1s and some 2s. I see a lot of 2s. I think a lot of you guys are yeah, I don't know if he's going to get it. I don't know if he's going to get it, AV. The 1s are he should get it. He should. He should, but will he? Right? Yeah, I'm seeing. Okay, all right. Lightning dropped it 5 times. Lightning is 1, 1, 1, 1, 1. I get it. Let's keep going. So that's Thug's bond. And that was probably the 3rd or 4th document that we saw today. Brian Steele's team put that in. Now we are going to Shannon Stillwell. Let's make myself small and let us zoom in. We got another document from Shannon Stillwell. And guys, all of these documents are from this afternoon. That's kind of why Lead and I were we cannot finish this. This is a lot of work. We knew it was going to be a long day, but I'm going to go ahead and finish these things. The ones that we have skimmed through, we'll go from there. So Shannon Stillwell, Attorney Shard represents him. And what Shannon put in motion for, they put two documents in today. One was for a fair and constitutional trial. I am going to zoom into this one. We are going to skim through it and go to their second document, but we're almost done. So Shannon Stillwell, through his counsel, hereby files a motion for a fair and constitutional trial in the above style case. In support of this motion, Stillwell shows as follows. Stillwell is accused of multiple felonies, including conspiracy to violate the RICO law and substantive felonies in this indictment. Stillwell is factually innocent of the charges against him. Like all citizens, Stillwell is guaranteed a fair trial and due process at trial by the federal and state constitutions, the Confrontation Clause, the Due Process Clause, and all constitutional protections. Stillwell demands that his trial be conducted in a fair and constitutional manner. This is actually different. I like it. I like the strategy that they're going in for this defendant. Shout out to Attorney Sharp. What they're doing with this is, instead of, and I predicted this, many people predicted this, we knew as soon as this judge got assigned, they were going to get motions for mistrial. That's why I called this, what do we call this stream? Motion Mega-Thon. They were all raining from the sky today. I even said that to Thugger Daily earlier. I was just like, it's raining motions. They were all just falling from the sky. We knew that motions for mistrials were going to come in. This one is cool. And I think another one of the legend attorneys filed one too. So I want to zoom into one of those paragraphs as well. Now, motion for a fair and constitutional trial. As you can see, if you're a new judge, you have 6 defendants and everybody's coming to you like, here are all the problems we have with the last one. I like this approach though. I like this approach of just saying, hey judge, everybody else is going to tell you about a motion for mistrial. We're going to co-sign that one. But what we want you to do is to make sure that this is constitutionally fair. So let's see what they say here. I'm going to zoom in a little bit more so y'all can follow along at home. The state is seeking life without parole. They were looking for that sentence for Mr. Stillwell if he's convicted. And Mr. Stillwell's constitutional rights must be protected without exception. Mr. Stillwell and his co-defendants have been on trial for approximately 19 months, guys. 75 witnesses have testified so far. Mr. Stillwell has remained in jail for the duration of this trial. Judge Glanville has been on trial to this point. This case has been plagued by discovery violations, lost and missing police reports, and Brady violations. The defense also takes issues with several of Judge Glanville's legal rulings, including but not limited to an overly liberal and unconstitutional, let me read that again. Including but not limited to an overly liberal and unconstitutional application of OCGA 801D2E. Most recently, Fulton County District Attorneys Hilton and Love took part in an ex parte meeting with Judge Glanville. This meeting also included Little Woody's attorney, Caleb Bumpus. Neither Mr. Stillwell nor undersigned counsel were informed or invited to attend this meeting. The same is true for all of Mr. Stillwell's co-defendants and their counsels. Kendrick filed a motion to recuse Judge Glanville. Judge Glanville summarily denied said motion. Kendrick's motion to recuse, as well as similar motions filed by co-defendants Williams, were subsequently considered and granted by Honorable Judge Rachel Krause. Mr. Williams, through his attorney, has since filed a motion for a fair trial on July 10th. So this isn't the first one that we've seen. This is the second one that we've seen. Williams' motion alleges and discusses several ways in which this trial has been unfair and has failed to meet constitutional requirements for Mr. Williams. Mr. Kendrick, through his attorney, has also filed a similar motion on July 23rd, 2024. Mr. Stillwell adopts both motions and incorporates their contents into this motion, as Mr. Stillwell has been similarly affected by errors in this case. Here we go. This is where it's formed for him. Mr. Stillwell does not wish to demand a mistrial absent jeopardy attaching. Okay, jeopardy. He wants to make sure that if we do a mistrial, we need to add that double jeopardy clause, okay? Like that, okay? We need to do that, right? Mr. Stillwell has been incarcerated since and has suffered through the duration of this case. Starting trial all over again is not a viable option for my client. Furthermore, the defense has completely neutralized all testimony and documentary evidence presented against Mr. Stillwell thus far. In other words, the defense is winning. The defense is winning this trial. Shout out to Shard for putting that in there. What has the state shown us? What compelling evidence have we seen? Max was brilliant for this, and I really wish I had the opportunity to talk to him, but the state might have a problem with that. So we're gonna communicate with Max in these documents, okay? 75 witnesses. I would have loved to ask Max more about his client. And he's telling you right here. The defense is winning this trial. The defense is winning despite the persistent legal errors, Brady violations, ex parte meetings, and discovery issues that have plagued this case. Mr. Stillwell does not request this to start. Mr. Stillwell does not request to start this case over. Nonetheless, serious errors have tainted this trial and continue to prohibit Mr. Stillwell from receiving a fair trial, from confronting witnesses called against him. Mr. Stillwell's due process rights have been and continue to be violated. These errors, as described in details and Williams and Kendrick's motions, have been caused solely by the Fulton County District Attorney's Office and Judge Glanville. These errors cannot be cured by curative instructions and will ultimately prevent these proceedings from meeting federal and state constitutional requirements, adhering to the Georgia rules of evidence, and fulfilling the requirements of Brady. Wherefore, undersigned counsel respectfully requests this court considers Mr. Stillwell's arguments and issues an order for which will fully and adequately protect Mr. Stillwell's constitutional rights. I mean, shout out to Max. This is my favorite one of the night so far. Seriously, because if you notice it, you got to know, like, everybody else is going to go in for a motion for mistrial, and that's fine. But what he's saying, and this is done by Steele, so we're going to give Steele his due. We're going to give Steele his due. But Team Young Thug and Steele and Adams have already filed a motion for a fair trial. But now that you have a new judge coming in, what I like about their approach out of all six is like, hey, I know everybody else is going to file this other thing. I'm just telling you, all we want is for you to do this the right way and for this to be fair. My client has sat here in jail for years. We watched 75 witnesses. We've cooperated. And honestly, Shart has been one of the most vocal attorneys in this entire case. And I wanted to bring him on so bad. I'm so sad I couldn't. Him and Steele would be so cool. But like, you will make do. We'll make do. But like the fact that he said, we winning. He's like, where they at? We winning. Okay. So that was one of my favorite filings to have read today. Let's continue on because we have a few more. And again, guys, did I go through all of them? Is that all 5 or all 7? That might actually be all of them. Let me make sure. So 1, I have State versus Jeffrey Williams. I read that to y'all. State versus, this is Quay Nichols. Let's go into this. This comes from Bruce Harvey. Oh, yeah, ready to go into one of the legends. Let's go into the legend. Let's go into the legend. Let me make sure, if I go to the bottom, just make sure this is Bruce's document. Yes. Okay. So you guys remember the man that comes into court. He reminds me of Boots. And he has like the silver hair, this long silverback hair, and it's like in a braid. Bruce Harvey, one of the most revered criminal defense attorneys in Atlanta. You would want, if you got bread out there, you would want Bruce or you would want Bryant. Like, but at the same time, I mean, I got some new respect for Shard. I'm like, wow, even like Doug's great. But like, let's go into this one because I did hear that this document was also super, super unique. Shout out to Authentic Vibe. He knows. It's like the ponytail. Let's go into this one because he also goes in a little bit differently. And again, like so much of this is legal strategy, guys. And like that's why I get so upset that we're being suppressed from discussing things and educating the public on how the law works. That's what's really disappointing to me. And if I had a friend or somebody in the prosecutor's office, like, come over here all day. Like, I know the thumbnail we can change. If y'all want to make peace, we could do it. But like, when you suppress First Amendment stuff, like, I don't know who's running that media office, but we should talk. That's all I'm saying. All right, let's go back in here and let's see what Team Harvey and Nichols have to say. So as mentioned, we knew a lot of people were going to do a motion for mistrial, so we see that. But in addition to that, they object to mid-trial substitution of the trial judge. So they don't like the fact that after Glanville left, that somebody else is coming in. So let's see what they have to say here. So comes now, let's just call him Quay Marvius Nichols, by and through the undersigned counsel, files this motion for mistrial in the above captioned case. In support of this motion, Mr. Nichols shows the court as follows. Mr. Nichols adopts all motions and arguments for a mistrial as filed by the co-defendants. If such motions are denied, sorry guys, it's late on the East Coast, Nichols further moves for mistrial and objects to mid-trial substitution for the following reason. You see that? Do you see how every defense attorney has their own style of argument and they're bringing in things from a different lens? Harvey is like on Steele level, probably a little bit higher. This is probably the most important part of this whole stream. Oh my God, let's go. I'm such a nerd. Let's go. So, and let's zoom in so y'all can follow along at home if you're watching on the big screens. Mr. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge because here, for a judge to be substituted after 19 months of trial, including 6 months of testimony, and the admission of evidence prejudices the defendant's right to a fair trial under the 6th and 14th Amendment of the United States Constitution, as well as concomitant provisions of the Constitution of the state of Georgia. Further, and notice this, his argument's beautiful so far. One, he's already starting with federal law. He's bringing you to the United States Constitution. Then he's bringing you to the state level. Oh, this is great. Two, further, Mr. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because the current presiding judge was not the judge during the last 19 months of trial. I mean, facts. When, for example, Mr. Nichols moves for directed verdict, this court will be unable to adequately evaluate the entirety of the prior proceedings in order to rule on the request. Oh, y'all better type Harvey in the chat. How can she do it? She doesn't know that he's right. He's right. Can y'all type Harvey in the chat? Thank you, Kat. Thank you, green eggs, no ham. So, and it sucks because if any new judge comes in, how are they going to know what happened for the last 19 months? If I say, hey, I want to move for a directed verdict because of this, and this, she is now going to stop everything to go and have to get back up to speed to learn what happened to make a verdict. Yo, this is the best part of this entire stream. Shout out to Harvey. Listen, we team defense over here. I mean, like, I invite prosecution opinions, but like, listen, he cooking right now. He is cooking. Let's keep the oven going. Of the 19 months of trial, over 6 months have been testimony for which this court was not present and therefore cannot base its decision on what has occurred during trial. Additionally, Mr. Nichols moves for mistrial and objects to mid-trial substitution of the judge because, I like this, whenever people start sentences and then they tell you why, like with because, I do that on my bar exam questions. Like sometimes, like I say something and then I just go to because. Anyway, sidebar. On Friday, July 18th, this court advised the parties that she was unfamiliar. Oh, he's already coming at the new judge. Oh my God, this is good. Oh, I'm fanning myself. Sorry guys. This sentence just got me excited. I'm going to read it again. Additionally, Mr. Nichols moves for mistrial and objects to the mid-trial substitution of the trial judge because on Friday, July 18th, this court advised the parties that she was unfamiliar with the previous trial proceedings that have occurred over the last year and a half. During the trial, before this court became the presiding court, Judge Glanville made several contingent decisions, noting that he would revisit his rulings as the trial proceeded. These contingent rulings covered several aspects of the tentative admissibility of evidence. Given the fact that the current court is unfamiliar with over 6 months worth of testimony, arguments by the parties, motions by the parties, and contingent rulings, this court could not possibly make decisions based on what has occurred, which the court was not privy to, nor has reviewed the record. This is a great point. How is she going to get brought up to speed? How is she going to properly rule? Green eggs, no ham. I mean, This is probably the best argument. I was really impressed with Shard, but let's keep going. Oh my God, this is great. Okay, Mr. Nichols further moves for a mistrial and objects to mid-trial substitution of the trial judge because, here it is, because Nichols specifically on several occasions during the trial moved the court to give curative Rule 105 instructions. Okay, tell us more. The court denied each request to give such instruction at the time, but indicated it may be necessary to give at a later time or at the end of trial. I do remember Glanville saying that a lot. Mr. Nichols also moved the court for severance on multiple occasions, which the court denied at the time, but agreed that a time may come that the issue would be revisited. I'll say it. I'm not a lawyer yet. I should be barred soon, but I guess I can swear on the internet. That's fucked up. What Bruce is saying is that he's been trying to sever his client from the 6 and take it to trial by himself. And Glanville kept saying no. He can't even get his client cut off the damn case. This is such a shit show. This court would now need the benefit of 6 months' worth of previous testimony to adequately and fairly make decisions regarding whether an instruction or a severance is warranted. Given the court is unfamiliar with the trial proceedings and has indicated that it did not intend on familiarizing itself with the trial proceedings, Mr. Nichols' constitutional rights are violated because this court cannot make informed rulings based on the record. Oh, Harvey strikes. What did Harvey just say there? I remember him asking her. Harvey asked her. If y'all are day ones, you were there when Lead and I watching this, what was it, Thursday, Friday? He was one of the only attorneys that stood up and had an objection. He did ask her what the plan was. And she said she didn't have plans of like going back to everything. Kalia, like, I'm telling y'all, he asked her many times. And when she said she didn't have plans to go through all that back footage or whatever the case may be, because in a sense, guys, I'll be fair, she did need to get up to speed quickly. She was just reassigned to this case. But Harvey's point is actually a good one because, like, Judge, what if I need you to rule on something immediately? My client has been sitting in jail for years. We've been trying to get him severed. But like, if I tried to get him severed with you and the last judge just tried to get him severed a million times and we couldn't get him off, how is this going to work? This is an amazing argument. Trials evolve and decisions are made by the court based in part on the way trial and evidence play out over time. This court has missed crucial proceedings necessary to make fair and well-founded rulings to properly instruct the jury both during and at the conclusion of trial. Nichols moves for a mistrial and objects to mid-trial substitution. Do y'all see this mastery? Because he's being professional. Like, he's saying to the judge, like, it's not necessarily your fault. You just weren't here for everything that happened before. So it's like mistrial, like everybody else is saying. But what we're saying is a mid-trial substitution. Let's keep going. Let's keep going. So he says mid-trial substitution of the trial judge, because, I love the because, this court has indicated that it does not intend on reviewing the complete record, including trial proceedings and litigations that have already occurred. for this court to step into a 19-month ongoing trial in which over 100 witnesses have already testified means that this court is proceeding with trial and unable to assess core trial functions, such as the credibility of witnesses that have already testified. The lack of trial court being personally familiar with the record, but presiding over the continuation of this trial, making decisions regarding the trial, and instructing the jury violates Nichols' right to due process and a fair trial as granted by our Constitution. Mr. Nichols further moves for a mistrial and objects to mid-trial substitution of the trial judge because even if this court attempted to read the transcripts of the past 6 months worth of the trial, that would not be an adequate substitution for the court observing live testimony. Even if this court attempted to watch 6 months worth of trial proceedings like us guys on YouTube via media recordings from afar, that would not be an adequate substitute for the court's personal and direct observations. If there was an argument to the contrary, Nichols notes that the media was not allowed to film several witnesses and at times were not recording due to technical difficulties. Oh, man, we gotta give it up to... Do y'all remember all them times when the mics were all fucked up and people were like, sorry to hurt y'all ears. The mic sounded like that, like just all fucked up. We couldn't hear a lot of stuff. We couldn't see a lot of people. Witnesses were being badgered all over the place. People were lying. There's 100 of them. What is going on? Y'all got me in rare form tonight. But like, he's right. Like, even if she were to go and look at all of the recordings, what Harvey is saying is like, you wouldn't have all of the recordings because some of those things were not recorded properly or they weren't recorded at all. So how are you going to know? Let's keep going. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge because the trial has been suspended for over a month. That's right. And jurors cannot reasonably be expected to just pick up where they left off with their memories and observations intact. Facts. If anybody is cooking, it's Harvey. How? The jury's been gone for a month. Lil Woody's living his best life. He was in a pool. He's over here. Tay got killed. He's still over here. He's over there. He's doing interviews. 21 versus 1. All of that. This jury's been gone for like a month. And Miss Sylvia was saying that all of them are just like spinning in chairs, not giving a shit. This is my favorite legal document ever. So far. But like when he says the jurors cannot reasonably be expected to just pick up where they left off with their memories and observations intact. He's not kidding about that. Furthermore, a mid-trial substituted judge cannot adequately instruct the jury regarding previous proceedings which the judge is unfamiliar with. Further, Nichols reiterates and realleges his request for a severance and incorporates his previous arguments that an enormous amount of prejudicial spillover has already occurred. And no jury can be expected to compartmentalize the evidence as it relates to separate defendants and charges. Wherefore, the defendant moves this court for a hearing on motion for mistrial and objection to the substitution of a trial judge. Respectfully, Bruce Harvey. Oh my God, let's give it up for Bruce Harvey. Wow. Oh my gosh, that was amazing. Wait, hold on. I think I got something for him on his soundboard. Listen to this guy.
As far back as I can remember, I always wanted to be a gangster.
That's Bruce Harvey. Like, that's just it. Like, it's just, oh my God, that's just the Bruce. That was amazing. That was amazing. Let's keep going, guys. I think I'm almost at all of the documents here, but that one was really good. Next up, we have Diamante Kendrick's. Lead and I went over this, so I'm not going to go over it too much here on my side. Shout out to Doug. I think we went over this full document now that I'm seeing it. But again, this is a motion for a mistrial from Doug Weinstein and Diamante Kendrick. This looked very, similar to documents we've already shown you guys. More of the same stuff. I'll try to go through some of the captions, but the mistrial is required because of the ex parte meeting, but really it should be had because the ex parte meeting took place and Little Woody was still on the stand after the fact. And that's what this particular attorney has an issue with, and that violated his client's rights. Next caption is motion mistrial is required as Chief Judge Glanville tainted the proceedings by improperly coercing Little Woody to testify. We've talked about that. You guys are all familiar with that. I'm going to skip ahead here to see if there's anything new. There's some new case law from what I can see. And yes, this was just refiled today, but we knew it was coming. I think Team Kendricks has one other one. Oh, okay. Let's go back to Max. Max has another one right here. This is a banger. Max wants, and again, sorry guys, if y'all left supers and cash apps, I'm gonna come to them. But like when I get like lit and like not lit, but like just really excited about legal documents, like I nerd out over them and like all the T's in here. This is fun. So Max filed this one for Team Stillwell. This is their second document of the day. Now, Max wants hearsay documents, or he wants to talk about hearsay. For those that watched the trial with us, if you really paid attention to Max in the last month, every time Simone would say something, or remember those jail phone calls, because Little Woody was getting difficult on the stand. Little Woody was up there and he was getting difficult, like, huh? What you mean? They my shoulders, all those things. I got an editor working on that right now. All Little Woody's difficulty. Star witness, we want to talk about defense attorneys, but star witness is still running around saying what he's saying. Whole nother story. When they lost control over Little Woody on the stand, and he wasn't saying what they wanted him to say, because even Fonnie Willis is like, he is an important part of this case. He's a very important witness in this case, to the point where they gave him use immunity. Immunity, even if he pled the fifth. Little Woody testified for 4 days. We all watched it. Some of y'all watched it with us live. Some of y'all didn't. We watched it. Now, the issue, if you paid attention to Max is one of the number one attorneys that was like, that's a hearsay statement. What is hearsay, guys? And I wish I had my little pointer, and this is where my editors help me convey this message to y'all. But what is hearsay? It is an out-of-court statement made for the truth of the matter asserted, right? And it's usually, the way you can picture this in your mind, is it's something that someone else said to another person. It's not direct knowledge. You said it to another person or you heard it from another person. Hearsay, right? Like picture the little Sesame Street joints. I said this to you, but you see me in the middle, like you see AV in the middle. This person said this to AV. AV says it to this one. Hearsay. Now, hearsay statements are a problem because they can be admissible. And I wish I had my little book. I miss my studio. But listen, there are like 20 exceptions to the hearsay rule. Max and Simone were going back and forth on the hearsay rule a ton because Max kept saying, hey, what you're trying to bring in can't come in. And mostly this came in when she lost control of Woody and she was trying to bring in those videos. She was trying to bring in the videos that none of us can hear and that were raping our ears. Sorry, graping our ears with the terrible audio in that courtroom. But they were trying to bring in Little Woody's interrogation footage. And Max kept standing up and saying, this is hearsay, because at the end of the day, it's footage. Little Woody can speak on it because he was there, but the other detectives, those people are not in the room right now. It's hearsay evidence. And Simone kept coming back and saying, no, it's not hearsay evidence because we're using it to impeach Little Woody. Judge Glanville kept allowing that to come in. Now, let's go to what Max says in this documents, because I specifically remember Max standing up a ton to talk, to have hearsay objections. So let's see what he has to say, because this document also came in today, guys. It's rain in motions. It's rain in motions. Let's see what he has to say. Here comes now Shannon Stillwell, by and through undersigned counsel, hereby files this motion for reconsideration in the above style case. And that looks a little small. Let me bring it up a little bit. There we go. Okay. Mr. Stillwell is accused of multiple felonies, including count 1, conspiracy to violate RICO, and specific substantive felonies. Mr. Stillwell is innocent of all of the charges against him. Mr. Stillwell is charged with the January 10th, 2015 murder of Nut Donovan Thomas and count 2 of this indictment. Mr. Stillwell is innocent of that charge as well. Here we go. Little Woody, a witness called by the state, is currently a witness on the stand. Little Woody has never claimed to have had any firsthand knowledge regarding the death of Nut. Little Woody did, however, meet with law enforcement several times in 2015. On June 10th of 2015, and what was Little Woody's 5th meeting with law enforcement, for emphasis, Little Woody told law enforcement that he possessed specific information regarding the shooting death of Nut Donovan Thomas. Little Woody made this claim while under the threat of arrest for unrelated crimes that law enforcement was investigating. Little Woody did not mention this information on any of the 4 prior meetings with law enforcement. This is why, right here, this is why I wanted to talk to Max. Don't sleep on Max, guys. As we move forward in this trial, don't sleep on Max, because who was going back and forth with Simone on these recordings? Who had to transcribe those recordings? Max and his team. Because it involved his client as like the number 1 suspect. Like, remember, they were saying that Shannon pulled the trigger and this and that. Woody said that. I could be wrong. It is alleged that Woody said that. Now, Max has intricate knowledge of these transcripts, intricate knowledge of all of those jail, not even jail, like those discussions he had with detectives, to the point where he's telling you right now, Woody had 5 meetings. 5 meetings with detectives. Let's keep going. On his June 10th, 2015 interview, Little Woody told law enforcement that he picked up Demekion Garlington at the McDonald's on Cleveland Avenue on the evening of January 10th, 2015. Little Woody reported that Demekion walked to Little Woody's car, and while the 2 men were briefly alone, Demekion told Little Woody that they, in parentheses, killed Nut. There's a footnote. What does that footnote say? Nut and Peanut were Donovan Thomas. Okay, all right. Demekion told Little Woody that they killed Nut. Little Woody told law enforcement that Demekion then pointed to a group of people who were pulling into the McDonald's. Little Woody told law enforcement that he interrupted Demekion's words and actions to mean that Mr. Stillwell, Mr. Kendricks, Mr. Justin Cobb, and Demise were all present for and all participated in the drive-by shooting of Donovan Thomas, aka Nut. Guys, what I need to point it out to you from a legal perspective too. When it comes to hearsay, remember that I said, she said, this person said. Everybody says this person said, this person said, this person said. You can even see it in his legal writing. This person said, this person told, this person told. Demekion told Little Woody that these people did the crimes. So that's hearsay. He's not lying. That is absolutely hearsay. And let's just run it back one more time. In this June 10th interview, this is why Max wanted, this is why he's going back and forth with Glanville. Little Woody told law enforcement, that's hearsay, that he picked up Demekion at the McDonald's at Cleveland Avenue on the evening of January 10th. Little Woody reported that Demekion walked to Little Woody's car, and while the two men were briefly alone, Demekion told, see here, there's that word told again, Little Woody that they killed Nut. Little Woody told, it's another indicator of hearsay, that Demekion then pointed to a group of people who were pulling into the McDonald's. Little Woody told 4 times law enforcement that he interrupted Garlington's words and actions to mean that Mr. Stillwell, Mr. Kendricks, Mr. Cobb, Mr. Demise were all present for and all participated in the drive-by shooting of Nut. Per Little Woody, Demise entered his car shortly after Demekion, and all communication about the event ceased. Here we go. Max about to break it down. Little Woody is now a sworn witness for the state and is currently on the stand. On direct examination thus far, Little Woody has not denied making this June 2015 statement to law enforcement. Little Woody has repudiated the contents and the veracity of his prior statement. However, Little Woody testified at trial that this conversation with Demekion never occurred, and that he, Little Woody, lied, fabricated the event to get himself out of legal trouble. Oh my God. Furthermore, Little Woody has denied contextual clues surrounding the out-of-court statement, testifying that it was Mr. Stillwell, not Demise, who got in the car with Little Woody and Demekion that evening. Do y'all see how Little Woody blew this damn case to smithereens? Like, do you remember the cartoon from back in the day that just Elmer Fudd just now, so there's like 6 defendants, and now with Stillwell, you have a problem because now Max is like, oh, you said you were lying? Max is watching from the back of that court, from the very back, the back row. In law school, we used to always watch the people in the back row. I sit in the back row. It is the best place for you to learn. I'm telling you, Max is like, oh, wait, you said you lying about that? You just said what you said to get out of trouble. So why is my client? Ay. This case is so fucked up. Let's keep going. I mean, I can't even hold it in, guys. Like, you're just going to get real AV from this point on. Stillwell has challenged the admissibility of Demekion's out-of-court statements on hearsay and confrontation clause grounds. Judge Glanville, who has since been recused from this case, ruled that these statements were admissible as statements of a co-conspirator. I remember that. This ruling does not comport with the U.S. Constitution or the Georgia Rule of Evidence. The plain text of OCGA Section 24.8.801 requires not only that the proponent of the evidence, 1, establish the existence of the conspiracy, 2, show that the statement was made during the pendency of the conspiracy, but that the proponent must also establish that the statement was made in furtherance of the conspiracy. Now, let me stop because I know that that's a mouthful. What Max is saying here is that Glanville said, hey, I'm going to allow Demikion's statements in. That hearsay, he says, she said, whatever the fuck, like all of that goes down the chain. Glanville let it in. Why? He let it in because remember what I said, guys. For hearsay, there are 20, there's 20 exceptions for it. One of them is a co-conspirator exception. So if somebody is in helping commit a crime, that hearsay evidence could come in. Glanville let it in. Now, what he's saying, what Max is saying, is that it shouldn't have come in because in order for it to have come in, it needs to come in under these 3 parts of the exception. He's fine-lining the rule for y'all. And again, I know this sounds like legal gibberish, but I'm just saying these are the 3 things that would allow it to come in. Let's see what Max says here. Assuming that Demikion actually said these things to Little Woody, these statements were not made in the furtherance of the conspiracy. There you go. So Max gave you 3 things. 1, it has to establish the existence of conspiracy. 2, it has to show that the statement was made in the pendence of the conspiracy. But the proponent, 3, must establish that the statement was made in furtherance of the conspiracy. Whenever people do stuff like this, when it's in italics, that's what they want you to focus on. Max says that these statements were not made in furtherance of the conspiracy. So if that statement was made, if Little Woody is not lying, because at this point, who knows? Even if the statement was made, and if we're going to still apply what Glanville said when he said it, when Demikion said that to Little Woody, when he said those people did it, when Demikion said that, was he saying it because Demikion was a co-conspirator and he was continuing on the crimes? The answer is no. To find otherwise simply overlooks, disregards the plain language of the statute and in line of controlling cases that establish the statements that spill the beans by definition, but do not further a conspiracy. He gives us 1, 2, 3. He gives us about 3 cases there. The state plans to elicit testimony from Little Woody regarding Demikion's alleged statements. While Little Woody is now denying that Demikion made such statements, Little Woody has openly acknowledged that he previously told law enforcement that Demikion made such statements. The state has attempted to improperly introduce the content of Demikion's statements through recordings of Little Woody's prior statements, including his June 10th, 2015 interview. The state's method is improper for 2 reasons. Break it down, Max. First, Little Woody has not denied making his prior statements, and therefore no foundation for prior inconsistent statements has been laid. Ooh, Max. Second, which is the focus of the motion, Demikion's statements to Little Woody, even if uttered, were not made in the furtherance of conspiracy and therefore failed to meet the requirements. Wherefore, undersigned counsel respectfully requests the court considers Stillwell's arguments and reconsiders whether the state has met their burden of establishing Demikion's alleged statements satisfy the requirements. Okay, respectfully submitted, Max Shard. Max came in with that, and I forgot about this, but this is what I mean, guys. This judge has to rule on so much I remember Simone and Max going back and forth on this for days. But that's what this new judge has to jump into. So this was also outstanding. Oh, all right, we got another one. There's so many. They just was rain emotions today. This one comes from Young Thug and state of Georgia. No. This is the state. I think I read this to you guys already. Yeah, this is that crazy one with, suppressing YouTubers. Here's another one. This is Young Thug's verdict, or actually his bond hearing. He wanted to get out on bond. I read that to you guys. Yeah, we've covered them all. We got through them all, y'all. Wow, we got through 7 legal documents in a day. Shout out to me. Let's see who we have in the chat. I'm going to read some supers, and of course, your girls got to get some sleep. It's going to be a long day tomorrow. It's going to be a long day tomorrow, but I hope you guys enjoyed that. I hope you enjoyed that breakdown. There are so many very skilled attorneys in this case. And I feel like sometimes, at least with the defense side, we really don't get a chance to get to know them or learn much about them. I've learned so much about them through reading their legal documents, believe it or not. And I was really pumped to bring some of them on. And that, there were at least 2 that I had agreed to chat. And whether we did that in a protected way, the way I do it on my side, especially being communications and a legal professional, I know what I can ask and what I can't, so it's just really unfortunate that the state filed that document today. And again, I understand why they did it. It hasn't been ruled upon yet, but if Judge Whittaker, if you deny that motion, I will absolutely have them on. I will have all of them on this side if I could. But let's go to the chat, see how y'all are doing, and we will wrap it up for the night. Shout out to Rod, who said loving this content. Get him AV with the popcorn. Thank you, Rod. Good to see you. Thank you so much for the super. Appreciate you. Shout out to Spitting Fire, sis. How you doing? Thank you so much for the $20. She says you're gonna be a good attorney. Listen, like when you just look at things from a strategy perspective. And a lot of it is not different from the way that most of us think day to day. It really isn't. If you just slow down a little bit, and just watch stuff, and you guys know I hang out with Lead all the time, for over 2 years, I've learned from that guy. So it's good. It's good stuff. It's really, really good stuff. I have a good time doing it. I'm a law nerd. I love this stuff. Sometimes I love it too much where it takes away from my studies, but I love talking about it. It's just fun to me. It's just so fun. So thank you so much, Spit and Fire. And if any of my mods are hanging out, please check out Spit and Fire's channel. Drop the link to that channel in the chat and y'all check her out. She is a sister to this channel. Thank you so much. Shout out to JT Corn Rings with a 199. Says hello, AV and chat. Good to see you, JT. Another content creator. If you're into checking out, if you're a coin collector and you want to check out, he actually does those type of videos. It's really cool. Do you see how I remember you guys? It's really dope. It's really dope. Shout out to the Lost Chicago girl. Since I haven't seen you in a super long time. She says, I love your hair. I love it too. It's very when I put water in it earlier in the conditioner and I was like, oh, this is going to look dope on the screen. Now it's 4 hours later. It's but you guys still like it. I'm glad that you like it. Thank you so much, Lost Chicago girl. Hope you're doing well. I think you have dogs. I hope the dogs are doing well. Shout out to Infiltrate Mindset with the $50. Wow. Thank you. Super generous. Says new YouTuber here. One of my subscribers told me I should follow you and the lead attorney. Great content. Infiltrate Mindset. Thank you so much. I appreciate this. This is in it. If this is your first time here, wow, that's super, super nice of you. Appreciate it so much. And if you're checking me out, I'm a live streamer, do legal stuff, and if you're interested. I do help out not only law students, but creators that want to learn how to do this. I do consultations, so you could check out the link in my description box below. But I'm sure you got it. I'm sure you're doing what you're doing if you're a content creator too. But just saying, if one of your subs told you to check us out, then you're in the right place. Thank you so much, Infiltrate Mindset. Welcome, welcome, welcome to the community. Shout out to Miss Kalia, says, you're really that girl. This is my first time catching you on your own channel, and I love your energy and deep insights. Yeah, I mean, when I co-host with Lead, like I have fun there, but like I have to, at the same time, we have to balance each other out. And it's his platform at the end of the day. So I always want to be respectful. But when I'm over here on my side, guys, I unleash, like, listen, we have fun over here. We do. We totally do. And I hope you guys had a really good time. Let me come over to the Cash Apps and say thank you to a few people. And again, I don't know if he's over here, but we were just on Lead side and Roy sent me $200. Like, whenever Roy sends me Cash Apps, I always hide. I'm like, oh, there it is. Like, I was so excited by that. But at the same time, like, if it happens while Lead's speaking or something, like, I just want to hold it because I'm like super excited when it happens. So Roy, thank you if you're watching right now. I so appreciate it. But then you get the Michael Loves in the building. Shout out to Michael Love, who sends me $100. And he says, for dinner tomorrow, back to steaks, all the trimmings. Listen, Michael Love is amazing. He sees how hard I work. There was one time I streamed on Lead side. I did 11 hours. No breaks, no nothing. I sat in that chair. I got it done. We watched this YSL trial and I explained to y'all how the law works. That's how much I love it. But like, Michael saw that hard work ethic and he was just like, yo, you need to eat. Go buy yourself a dinner. Here's $100. But like, that's why I love y'all. It's like men and women, and like the guys are like really, really supportive. Like, they're just like, go eat. Like, go get a steak dinner. This day, like on another day, if I'm working hard, he reminds me, he's like, get chicken tonight. Here's $100. Go buy yourself a chicken dinner. And I'll be like, okay. And I do it. I mean, it's a little late right now on the East Coast, but I will absolutely take it easy tomorrow. But like, people like Mike, y'all don't have any idea what you mean to like me and Lead, but y'all are amazing. And then I want to end the night, if I can, with Beth in Seattle. Hits me with 20. She says, all of your hard work. Thank you so much, Beth. And yeah, like, there's so much that goes into this, guys. I'm studying for the bar right now. I meet with y'all that are like trying to become creators. I meet with people that want to go to law school. I meet with founders that are showing me their businesses and stuff like that for brand deals and all of that. It's just busy. It is busy. And I meet with my editing team every day and we put out this heat for y'all. So there's 2 in the can right now. We got 2 videos coming. Shout out to everybody that voted earlier today. We're going to do a best of Brian Steele. That's in the works right now. I'm so excited about that one. And then we also just have a full status on this case. It's actually really funny, compilation of Little Woody. So we've got some heat, man. We've got some good stuff coming. I'm so excited. And then lastly, shout out to Raphael Bamora with $2. Thank you, Raph. He says, start over from the beginning. I missed everything. Raph, I streamed over here for 2 hours. We streamed on Lisa for 2 hours. Your girl is tired, okay? It is 12:41 on the East Coast. But I think I captured all the supers, guys. I just really want to thank y'all for being a part of this community. And yeah, everybody's like, you got your hair. Mike, I just put some water in it. This is what it naturally looks like. Anytime you guys are saying thank you. Thank you, thank you, thank you. Scott saying you're one of the best teaching women on different levels of psychology. I'm just trying to be myself. People have been asking me to do that, and I've been doing it and just literally being myself. Shout out to Mikey. He says, thank you. That was very well done. And you learned a lot. I'm so happy. I love you too, Adrian. Thank you, Kat, for dropping that. And then, guys, check out Kat. When I'm not here, Kat's here. And she hits you with the T fast. So check out Kat, not William. She's an amazing person. Amazing, amazing, amazing. All right, y'all. I'm going to get out of here. It's super late. I mean, I'm not going to use Lead's line, but you guys know I'm not a lawyer. I'm almost a lawyer. So know that none of this is legal advice, okay? We had fun tonight. These attorneys are amazing, and we're going to continue to watch it and continue to look at how this case progresses. Stay safe out there. Make sure your bell's on. Make sure your bell's on. Do it right now. Do it for me right now. Have a great night, everybody. See you soon. Bye.